message and a short welcome message from the Dean of the UST Faculty of Civil Law, Dean Nilo T. Divina.
Good morning, Renz. Good morning, Justice. Good morning, everyone. So on behalf of the University of Santo Tomas, Faculty of Civil Law, I welcome you to possibly one of the biggest online lectures to date. And I would say the biggest online lecture on the revised rules of CIVPRO and evidence with close to 3,000 attendees via Zoom and more, hundreds more via live streaming on UST Faculty of Civil Law website as well as the IBP QC chapter. I'm looking at my notes to make sure that I don't forget the IBP QC chapter. Likewise, they're also live streaming the lecture of Justice Bonet. Indeed, the current crisis has brought up a new normal, and thank God for the wonders of technology that we can continue performing our duties. Just recently, we all know that the Office of the Chief Justice, of course, our very own from UST likewise, Justado Peralta, held its first webinar on cyber security. And then recently, the Office of the CJ likewise rolled out what they call Philippine Judiciary 365, a platform where pleadings can be received electronically. And let's not forget also the first ever virtual retirement ceremony of Justice Andy Reyes. Now, for our part, this is basically part of the continuing trust of the UST Faculty of Civil Law and the Divisional Law Foundation to enhance the quality of our legal education and to keep all the stakeholders of legal education, to give them engaged in spirited discussion, and likewise keep them abreast of recent developments on law. We had our webinar likewise on domestic violence, on the new rules, or not new rules, but the revised corporation code. And soon we'll have a webinar on e-commerce, on immigration, and then remedies available to financially distressed debtor. But for now, I think all interest is on the new rules of court, which took effect on May 1. So despite the lockdown, it took effect on May 1. So I'm sure you have many questions later. Now, somebody said that the lawyers like to learn, but they don't like to be taught. Well, I'm sure that with Just Monet Singh, we will learn without the feeling of being taught. She's not only a competent magistrate, she is an educator by heart. She's a member of the PhilJA for two departments, remedial law and legal ethics, and she's the chairperson of PhilJA on continuing legal education. She's likewise a professor of Ateneo, and I'm proud to say that next semester she'll be part of the talented, I may say, roster of the UST Faculty of Civil Law. So without further ado, let's hear from Justice Bonetsi.
Thank you very much, Dean. Good morning to everyone. Thank you for devoting your time to this lecture today and hopefully also for tomorrow. First, I really want to say thank you to Dean Nilo Divina. After the release of the results of the recent bar examinations, I texted him immediately and told him, I salute him because of what he's doing for legal education. And that is a passion for me as much as judicial education is a passion for me. And so when Dean Nilo earlier described me as an educator at heart, he really spoke the truth. I think I am more a teacher than a jurist, at heart. So I'm really happy and privileged to do this lecture for all of you. Actually, I don't want to call it a lecture. I want to call it a sharing. This is my understanding of the revisions. What we will do today, considering the limited time, is to walk you through the revisions because that is the urgent thing for all of us today, considering, as the Dean mentioned, the rules took effect already on May 1st, 2020, and we still have a dearth of exposition to it. So this is your chance now to be exposed to these revisions. So please do not expect an in-depth discussion of evidence concepts, except that in my presentation, I made the necessary references to jurisprudence to guide you, but we will not discuss them today because as I said, we only have 2.5 hours. But they are in the PowerPoint so that you can refer to it at leisure. And the PowerPoint will be made available to you after the lecture today. So we will go ahead, and Attorney Renz will assist us in operating our slides. Let's go to the first slide. So the amendments to the revised rules on evidence are of three types. No? First, we have the amendments which are substantive in nature, and they are by reason of technological advances that have happened, and also to incorporate developments in law and jurisprudence as well as international conventions. Then the next group of amendments refer to just renumbered provisions because there was an insertion of a new provision, or we also have new provisions, entirely new provisions, and we also deleted some provisions. And then the third type of amendments done to the rules are amendments for gender inclusiveness only. Okay, so those amendments, we will just go past them, but I will point them out to you, at least the rule number and the section numbers. Okay, so we'll start with the general provisions under Rule 128. So Section 3 refers to admissibility of evidence. No, there is a change here. The Supreme Court added the phrase "the Constitution." Of course, even without adding that, that was already a given, no? But now it's clearer. The provision now reads, evidence is admissible when it is relevant. So that's the first condition of admissibility of evidence, relevance, no? And then the second half is when it's not excluded by the Constitution, the law, or the rules, okay? So that's competence. That's the second part. Let's go to the next slide, please, Attorney Renz. Okay, so there you have it. I have a definition of relevant evidence and competent evidence for you. So for your own reference later on. But as I mentioned, even without the phrase "the Constitution," which was of recent addition, we already acknowledged that the exclusionary rules in the Constitution, for example, illegal searches and seizures and evidence obtained through illegal searches and seizures, are excluded and deemed incompetent under our rules on evidence. So let's go to the next slide, Attorney Renz. Okay, so this is just a review. Relevant evidence plus competent evidence equals admissible evidence. So you have two things here. First, the requisite of relevance. Second, the requisite of competence, which results to admissibility of evidence. But then that is not the end all and be all. You don't just need to have your evidence admitted in order to win your case. You also need your evidence to be credible and to have sufficient weight. And that is where you have the weight of evidence. And we will discuss that later under Rule 133. So here I just have some, before we leave that slide, Attorney Renz, I just have some jurisprudence there discussing the difference between admissibility and weight of evidence. Okay, we can go to the next slide now. Right, so what need not be proved? Okay, so the title clues us as to what will be found in this rule, no? So judicial notice is the first one, and then the second one will be judicial admissions. When you speak of judicial notice, you dispense with proof, okay? So the court takes judicial notice of a fact and dispenses with proof, meaning the party who has the burden no longer has to prove that particular fact, okay? That is what judicial notice is about. And that is the same thing for judicial admissions later on when we go to Section 4, okay? The only change in Section 1 under mandatory judicial notice is that the Supreme Court made a clarificatory insertion of the phrase "the national government" in reference to the official acts of the legislative, executive, and judicial branches, because there have been questions raised in cases decided by the Supreme Court about local government units. And that is why the court decided to insert the phrase "national government." We can go to the next slide now. Attorney Renz, we can go to the next slide. Okay. Okay, so Section 1, judicial notice when mandatory. That means the court, without any motion, has to take mandatory judicial notice as a matter of course, no, as dictated by the rule. But under Section 3, okay, it still speaks of judicial notice, but here a hearing is required, no. The insertions here, or the revisions here, refer to the time when you ask the court to take judicial notice of a matter of fact, but the requirement now is that you must set a hearing for it, no, with both parties being given an opportunity. And the earliest possible time when you may raise this issue is during pre-trial, and that is part of the revision here. And then the court just clarified that the court may do this motu proprio or upon motion, but the important requirement is that whether it's motu proprio done by the court or upon motion, there must be a hearing where both parties are heard on the matter, all right? And you will also note, okay, although this was already in the prior rule, that this is available even on appeal, okay? Now, the next slide only gives you, an example of when judicial notice by motion or by the court motu proprio should have been subjected to the required hearing, no, as an in observance of the right to due process. Here, in the case of Land Bank versus Honeycomb Farms, there was no hearing conducted. The court just motu proprio took judicial notice of the commercial nature of the land in fixing the just compensation, no. And that is why the Supreme Court had to reverse the trial court in this case, right? Let's go to the next slide. Now we go to judicial admissions. Now, this is the other item under the rule on dispensing with proof, no? So why is it under judicial notice? Because, as I said, it does away with proof. We know that if there is an admission, it becomes conclusive on the party admitting it, no? Unless it is proven to have been made through palpable mistake or that the admission was in fact not made. So the only change done here by the Supreme Court is to change the word verbal to oral, no? And towards the end of the provision, the court just clarified it's a stylistic change to say that the imputed admission was not in fact made rather than the previous formulation, right? Let's go to the next slide. Well, the next slide is important for our judges. I think a lot of our judges are listening now. When may a party's judicial admissions be taken notice of by the court, no? If they are made in the following instances, no? In the pleadings, in that particular case, during trial, no? And then C, in other stages of the judicial proceeding. Now, this now has been institutionalized in the change in that particular, in our Section 3, when the court included the phrase pre-trial, no? All right, let's go to the next slide. Now we go to Rule 130. This is the longest rule, no? So we start with the first type of evidence, which is object evidence. It used to be referred to as real evidence, but then we now call it object evidence, no? So what are objects as evidence, no? They are those which are addressed to the senses of the court, and they are those that have to be exhibited or viewed by the court, no? Now, in the hierarchy of trustworthy evidence, physical evidence or object evidence always ranks at the topmost. And why is that? Because it is neutral or impartial, no? It is not partial to either party. It is mute, no? And unspeaking. It does not favor one or the other party. And that is why the Supreme Court in jurisprudence always favors physical evidence over testimonial evidence. Well, you very well know what the Supreme Court says about testimonial evidence, especially if there is a sufficient lapse of time already from the time that the incident being testified on has happened to the time that the testimony is being given in court, always referring to memory being so frail, no? Right, let's go to the next one. Then we go to the second type of evidence, that's documentary evidence. Attorney Renz, okay. Section 2 speaks of documentary evidence. Now we have a very substantive revision here, okay? And I urge all of you to actually listen to this, no? So this revised provision now provides documents as evidence consist of writings, no? And then the Supreme Court added recordings, photographs, no? Sounds also, or their equivalent. And towards the end, it speaks of photographs, which shall include pictures, drawings, stored images, X-ray films, motion pictures, or videos. Why is this substantive, no? We are now shifting from our old or traditional concept of documentary evidence as just paper evidence, okay? So paper evidence, which contains any writings or images or symbols, no? now we are including even recordings of sounds, no, as evidence. And this is actually to make our rules on evidence consistent with what we already provided for much earlier, under the rules on electronic evidence. No, under the rules on electronic evidence, you have electronic documents where anything which is electronically transmitted or stored or sent or received or processed is considered as documentary evidence. No, under Rule 3, Section 1 of the REE, whenever a rule of evidence refers to writing or document, it also refers to an electronic document. Okay, and so by the Supreme Court in revising Section 2 of Rule 130 is actually just making our rules on evidence consistent with the rules on electronic evidence. Okay, so let's go to the next slide, Attorney Renz. Okay, so now we have an expanded definition. Can we go back, Attorney Renz, to the previous slide? There you go. Okay, so now we have an expanded definition of documentary evidence. So now we are no longer just confining documentary evidence to paper evidence or to written documents. Okay, now we are including recordings of sounds, also video recordings, photographs, drawings, sketches, etc. Where did this come from? We are taking this from the Federal Rules of Evidence of the US and also from the Uniform Rules of Evidence proposed by the American Bar Association. No? And why did the Supreme Court think of expanding the definition? Because as I said earlier on, when the Supreme Court promulgated the rules on electronic evidence, the Supreme Court already recognized the international trend and also embraced the technological advances through which we do business nowadays and our transactions. And so by expanding the definition, we cover all, so we do not leave anything out. Well, as for photographs being documentary evidence, the Supreme Court has long recognized that in its jurisprudence, which classify photographs as documentary evidence, of course, subject to authentication. And authentication need not be by the photographer himself, as you will see from those cases that I cited for your use. No, all right. So next we have the next slide. Okay. Now we go to the original document rule. Okay, the next slide, please, Attorney Renz. Okay, so before you referred to this, or we referred to this as the best evidence rule. Now the Supreme Court is instructing us through the revision to call this the original document rule. Why is that? Well, because the Supreme Court said that the best evidence rule is a misnomer. Now, why is it a misnomer? When you say best evidence, you are actually confining it just to documents. The rule applies only to documents, no? But when you say best evidence, there are three types of evidence, as I mentioned already: object evidence, testimonial evidence, and document evidence. So the best evidence rule does not apply to all three types of evidence. It only applies to documents. And so it's more proper to say that it's the original document rule. But why not the best document evidence rule? Because it's confusing also. Why is it confusing? For the longest time, in trials that I've presided over, and even now on appeal when I review cases, there is a confusion between the best evidence rule and the parole evidence rule. A classic example would be a lawyer presenting a witness who will testify on a contract. And for example, the lawyer asks the question, Mr. Witness, what is the term in your contract, or what is the term of lease? Let's say it's a contract. What is the term of lease, in your contract, And then the adverse counsel will stand up and raise the objection. Objection, Your Honor. Best evidence. Best evidence. The best evidence of the terms is the contract. But the lawyer really wants to say parole evidence rule, okay? Because you don't want to add anything to the terms of the contract. Evidence their agreement. That's what you really want to say. But because of the misnomer, best evidence, the lawyers, sometimes even the judges, refer to it as the best evidence. Okay, what is the original document really all about? It just requires you to present the original of a document. If your case centers on the contents of a document, what the court wants to see is the original of the document that you are basing your claim or defense on. That's all that it says, okay? Let's go to the next slide, Attorney Renz. Okay, so there you have it. The best evidence with respect to documentary evidence applies only when the contents of the documents are in question, no? When it's the subject of the inquiry. So if the issue has to do with the existence of the document or whether it was actually executed, no? So there is no question as to the contents, no? The defendant is not questioning the contents of the documents. What the defendant is saying is that that document does not exist, no? It's a forgery, no? It's simulated. Then the best evidence rule, which we now call the original document rule properly, okay, will not apply, right? Okay, next. Okay, there are exceptions to the original document rule. And the exceptions are the same exceptions that we've had from before. It's just that the Supreme Court added one, no? There are certain insertions also, like in the beginning paragraph, we had to add writing, recording, photograph, or other record because of the amendment to our definition of documentary evidence. Okay, so the first exception is the exception for lost or destroyed evidence, those which could not be produced without bad faith on the part of the offerer. The next exception under paragraph B refers to documents which are in the control of your adversary, no, and could not be presented despite an order being issued to that adverse party, no. The Supreme Court, however, added another phrase here at the end. It says, or the original cannot be obtained by judicial processes or procedure, no, just in acknowledgement also of jurisprudence we've long had, no, regarding those documents originating from foreign jurisdictions, which we could not secure by compulsory process, no. The next slide, please. Paragraph C refers to numerous or voluminous accounts, no, which we will just discuss later on under the new section 7. And then under letter D, you have public records, okay? And letter E is the addition here, when the original is not closely related to a controlling issue. Why did the Supreme Court add this, no? We all know under Rule 128 in the general provisions that collateral matters are considered inadmissible, okay? And the reason is because we do not want to bog down the trial in irrelevancies, no? Relevance being one of the conditions for admissibility. Of course, there is an exception when the collateral matter tends in any reasonable degree to prove the probability or improbability of the issue, right? But here, the court said that we need to add this, no? When the original is not closely related to a controlling issue, then let's not have it cause any delay in the trial, no? Just accept substitutionary evidence anyway. It's not an issue, okay? So this is really a guidance for the judges, no? So judges, when the original of a document that is sought to be produced cannot be brought to court, but that document is not closely related to a controlling issue in your case, then you can admit substitutionary or secondary evidence, right? Okay, so this is what we call collateral matter, no? And it's also just an acknowledgement of Section 4 of Rule 128, that evidence is really our means, no, for finding the truth. And if you have all these strict technical rules hampering our search for the truth, then that is what causes delay to our litigation. Okay, let's go to the next slide. Okay, up there, can we go back, Attorney Renz, to the preceding slide, please, Section 3. There, I just have some examples for you of the additional or the revisions that the Supreme Court made. No? So just for your own perusal, okay? Next slide now. Okay, Section 4, original of a document. What is considered the original of a document? Okay, again, this is substantive, a substantive revision. We have to closely look at it. Okay, the provision as revised now states an original of a document is a document itself. Well, that's the classic definition. But now this is the important addition, or any counterpart, okay? Or any counterpart intended to have the same effect by a person executing or issuing it, okay? Now, an original photograph includes the negative or any print therefrom, okay? Remember that, any print from it. If data is stored in a computer or similar device, any printout or other output readable by sight or other means shown to reflect the data accurately is an original. Again, this incorporates the provision in the in our rules on electronic evidence, okay, with regard to electronic documents. Now, let's go to paragraph B. What is a duplicate? A duplicate is a counterpart produced by the same impression as the original or from the same matrix or by means of photography, including enlargements and miniatures, or by mechanical or electronic re-recording, Attorney Renz, next slide, or by chemical reproduction or by other equivalent techniques. No? So that is we have there the original provision, but now we added the part referring to electronic documents, okay? And then letter C, a duplicate is admissible to the same extent as an original, okay? So if it's a duplicate, it's admissible to the same extent as an original because it's deemed as a counterpart unless there is a genuine question which is raised as to the authenticity of the original, or number two, in the circumstances, it is unjust or inequitable to admit the duplicate in lieu of the original. This is a take or a copy from the rules on electronic evidence. Again, okay, let's go to the discussion portion. Let's go to the next slide. Okay, so the amendment in section 4A does not really modify our meaning of what an original document is. No, the original of a document is the original of the document which is at issue. Okay, the contents of which are at issue. Okay, it does not mean the very, very, very first recording or the very, very first memorial of that document. It just means the document that you have based your claim on. So the original of that is the original of the document that we are speaking of, okay? Now, the inclusion, as I said, of outputs from a computer, printouts from a computer, and printouts from the negative of a picture, no? Those are now also included based on our jurisprudence, prior jurisprudence issued by the Supreme Court, and also the rules on electronic evidence. Okay, let's go to the next slide. What are the kinds of original documents? Okay, first, you have documents where the contents are the subject of the inquiry. That is the traditional definition of the original of a document. Okay, second, now you have the duplicate original. Even before we had the revision, you already had decisions of the Supreme Court which acknowledge carbon copies or carbon sheets, no, as duplicate originals. No, next slide, please. And then you have letter C. These are the entries repeated in the regular course of business, which is now under the new section 7 called summary. So those are the three types of originals under section 4. Okay, let's go to the next slide. So what happens when the original of a document is unavailable? Okay, when we are allowed to present substitutionary or secondary evidence. So when the original document has been lost or destroyed or cannot be produced in court, okay, so this is the first exception, and there is no bad faith on the part of the offeror, then substitutionary or secondary evidence may be produced. Now, what substitutionary or secondary evidence may be produced, no, in place of the original? There is a hierarchy, and that hierarchy is found in this provision. First, you can produce a photocopy, okay, or a copy. Second, you can produce a document which contains a recital of the contents of that of that original document, okay? And then third, you can produce testimonial evidence. So that is a hierarchy that has to be observed. Now, the hierarchy is there for purposes of giving weight. No, it does not necessarily mean that if you don't have a photocopy or you don't have a recital in an authentic document, you may no longer present substitutionary evidence. You can still present testimonial evidence, but in that hierarchy, the weight also suffers from a comparative reduction. Okay. Now, what you have below are just is just the doctrine on the loss of or destruction of documents or unavailability. These are the requisites that you must establish to justify the presentation of substitutionary evidence. All right. Okay, so next slide, we have secondary evidence when the original document is in the control of the adverse party. Okay, we are familiar with this. The requisites are at the bottom of the page. No, you must give the adverse party reasonable notice to produce the original, but despite this notice, the adverse party must still fail to produce the original. In this case of Edsa Shang, the counsel for the defendant was present in court and undertook to bring the originals, but despite this undertaking and a sufficient lapse of time, he failed to do so. So the court admitted the photocopy submitted by the plaintiff, right? Okay, let's go to the next slide, Attorney Renz. Now we go to Section 7 summaries, no, which is a new provision. Actually, it's a recast of the older provision regarding voluminous or numerous records, no. So let's go through the provision together. When the contents of documents, records, photographs, or numerous accounts are voluminous and cannot be examined in court without great loss of time, and the fact sought to be established is only the general result of the whole, the contents of the evidence may be presented in the form of a chart, summary, or calculation. Okay? So this is really the new part here. This is what the court introduced here. No, this is actually a suggestion of the type of evidence that you can produce or substitute for the original, which is too voluminous and not really necessary, no, for you to prove your point. So this is guidance for the litigants, no, and for the courts as well, no, that they may take the form of charts or graphs or summaries or calculations. Okay. Next, let's go to the next slide, Attorney Renz. So now we have some renumbered provisions here. No, there are no changes at all to them, except that by the inclusion of the new Section 7 on summaries, we now have to renumber them. So we go to the next slide, parole evidence rule. Okay, the parole evidence rule used to be Section 9, right? And I already mentioned this earlier in comparison to the old best evidence rule. Now, what is really the parole evidence rule? No, when the terms of an agreement have been reduced into writing, there can be between the parties no other evidence of such terms of the contents of that agreement, right? So that is what you call the parole evidence rule, okay? But there are, of course, established exceptions to the parole evidence rule. When may you present other evidence of the terms of the parties' agreement, no? And the same exceptions hold. The Supreme Court did not make any changes to that. The only change that the Supreme Court introduced in the parole evidence rule is to add the word verified before pleading, no? So that is because not all pleadings are required to be verified, and the Supreme Court does not want us to base the admission of evidence contradicting a written agreement on an unverified pleading, now, because it adds some form of reliability or trustworthiness to the allegation that there is an ambiguity or an imperfection in the agreement, or that it fails to reflect the true agreement of the parties, etc. And that is why the Supreme Court now requires that pleading to be verified. All right? Okay. Attorney Renz, the next slide, please. Okay, and let's go to the next slide, to the discussion. All right, there you have it. Parole evidence, no? So these are the instances when oral testimony of a party who has an interest in the outcome of the case may be admitted in lieu of the written agreement itself, or to add to it, or supplement to it, or to even to change, no? Under these circumstances, okay, that the party's verified pleading, no, must have put in issue the ambiguity, the failure to express the true intent, the very validity of the agreement, etc. All right. Okay, let's go to the next slide. The next slide just gives you some jurisprudence on the issue of parole evidence. Okay. All right. Yeah, for your own reference later on. Okay. Now, the succeeding slides refer to the provisions on interpretation of documents. Now, these are merely renumbered provisions. There are no changes in them. If there are any changes, it will only be gender inclusive language, not to add the word her, no, to the masculine his. So we will just skip all of these because there are no changes to them. Okay, and we will go directly to testimonial evidence, Attorney Renz. Okay. So now we start with the qualification of witnesses. No, of course, under Section 20, there's no change in this. No, it was renumbered, but I thought of including this here because this is the proper place to start when we go to testimonial evidence. When is a witness deemed qualified to testify? No, and you have it here. If the witness can perceive and can make known his perception to others, no, then he is qualified as a witness. And all those things in the second paragraph will not serve as a ground for disqualification. Okay. Now, next to Section 20, the old Section 20, is the old Section 21, which is disqualification by reason of mental incapacity or immaturity. this now has been deleted, okay? It's no longer a part of the revised rules on evidence. And this is only to make our rules consistent with jurisprudence by the Supreme Court itself and also international trends. So we all know that mental retardation does not of itself affect the credence of a witness as long as the testimony is still coherent, no, and intelligible. In the same manner, because of the rule on examination of a child witness, every child is now presumed qualified to be a witness. Okay, right. So let's go to the next slide. Okay, you will see now that the old section 36, no, which previously preceded the exclusions or the exceptions to the rule on hearsay, was transposed by the Supreme Court. It's now section 22. So now it is under the chapter on qualification of witnesses. No, so first you have the qualification of a witness, which is the ability to perceive and to make known your perceptions. And then now you have this, no, that the testimony must be confined to personal knowledge. Okay, so this is a transposition from the old section 36. It is now section 22. So a witness can testify only to those facts which are of his or her own personal knowledge or derived from his or her own perception. All right, let's go to the next slide, the discussion slide. Attorney Rance. Okay, so this is an important change. Okay, so before we call this the hearsay rule, no? If you are not testifying on the basis of your personal knowledge, no, or on the basis of your own perceptions or observations, then you are testifying on hearsay. Okay, so that was our old conception of hearsay. Okay, testimony that is not based on one's own personal knowledge nor derived from one's own perception. The Supreme Court, with the revision, has now shifted. No, we are now no longer calling that hearsay. Hearsay is going to be something else, which I'll explain later. Now we call this lack of first-hand knowledge, which is more appropriate, correct? And easier to remember, right? So if you do not have personal knowledge, then you lack first-hand knowledge. No, that's so much easier to explain, okay? So that is why the objection now, if you did not see something happen personally, okay, the objection is not hearsay, but lack of first-hand knowledge, okay? So lack of first-hand knowledge. A witness can testify only as to facts of his or her own personal knowledge or derived from his or her own perception. What happens to the doctrine of independently relevant statement? Now, previously, we had the doctrine of independently relevant statement where a person's account or declaration to you, no, to the witness, may be testified on, but for the limited purpose of proving that the statement was indeed made to the witness, okay? But not to prove the truth of what was stated to the witness or related to the witness, correct? So that's the doctrine of independently relevant statement. No, it's a statement which relates what another individual told the declarant. It is admissible, no, based on first-hand knowledge, no, of what the other individual told the declarant. So it's not. Before we say it's not hearsay, it's independently relevant. Now we say it's admissible because it is based on first-hand knowledge. It's based on the perception and the personal knowledge of the witness because that is his recollection of what the third party told him. Okay, so it is not objectionable, it is admissible, all right? But still remains inadmissible to prove the truth of what was related to the witness. Okay, let's go to the next slide, Attorney Renz. Okay, here I have a quote from you, from one of the decisions of the Supreme Court. It starts with our traditional definition of hearsay, which is evidence is hearsay when its probative force depends in whole or in part on the competency and credibility of some person other than the witness. Okay, so that is our old definition of hearsay. Throw that away now, okay? Now we call that lack of first-hand knowledge, okay? But the rest of the quote here still applies, no? So it refers actually to independently relevant statements, right? Okay, let's go to the next slide, Attorney Ren, section 23. Now we go to the disqualifications of a witness, no? We started with the qualification. Now we go to the disqualifications. We start with the marital disqualification rule. Now the only change here is stylistic. The only change here is stylistic, as I said, no? Cannot is used instead of the old neither nor, okay? So That's the only change. Let's go to the next slide, Attorney Renz. Okay, so here I have for you jurisprudence, no, enumerating the reasons or the rationale why we have the marital disqualification rule. And of course, you're aware at the very core of this is the identity of the supposed identity of interest or community of interest between the husband and the wife, such that if that identity or community of interest no longer exists, then there is no reason to apply the disqualification. Now, in this case, no, the husband was charged with arson. He tried to burn down the house of his sister-in-law while his wife was in that house. No, so the wife took the stand for the prosecution because at the time that the fire was starting, the wife just happened to look outside the window of the house of her sister and saw the husband pouring gasoline. No, and so the wife was the material witness for the prosecution. Of course, there was an objection, and the husband invoked the marital disqualification rule. But the Supreme Court said there is no more any community or identity of interest between the two of you. They had been separated, in fact, for a long period of time, and the interests were definitely adverse, no? And so the court allowed the wife to continue the testimony, right? Okay, let's go to the next disqualification, Attorney Renz. Disqualification by reason of privileged communications. Of course, the first one is between the husband or the wife during and after the marriage, no? So we already know this. Okay, we'll go to the next one, the attorney-client disqualification. Okay. Okay, so you have the disqualification by reason of privilege. So the attorney, now there's an important addition here, no? An attorney or a person reasonably believed by the client to be licensed or to engage in the practice of law. This is important. Why is this important? Because we know of many instances where unscrupulous individuals who are not licensed to practice law mislead the public, no, and offer their services, even appear in court, no, brazenly calling themselves attorneys when they are really not attorneys, no. And so now we are going to base the application of this provision on the reasonable belief of the misled client, no, that the person is duly licensed to engage in the practice of law. Okay. The other addition to that is, aside from the gender inclusive language, is that or other person assisting the attorney, because before we had the secretary, we had the stenographer or clerk, but the Supreme Court added this phrase. And why is that? Because we know there are other members of, for example, of a law firm, no, in particular paralegals who help the attorneys in the handling of these cases. Okay. So what are the exceptions to the attorney-client privilege? No, now this is the major revision here. No, I'll discuss them one at a time. But before we go there, let me just remind you. It's here on the screen, but let me just remind you. This is a protection for all the lawyers out there. No, that the doctrine of absolute privilege protects a lawyer from all utterances and statements, written and oral. No, in any judicial proceeding. And the only condition for the application of this absolute privilege is materiality or relevance. Okay, so any statement that you make in any judicial proceeding is protected, meaning you cannot be sued for libel, you cannot be sued civilly for damages for it, as long as what you say or what you state is relevant to the issues in the case. No, the only thing that you may be exposed to is administrative liability for using intemperate or oppressive or abusive language, no, under our Code of Professional Responsibility. Okay, so let's go to the exceptions. Attorney Renz, the first slide. The first exception refers to crime or fraud. No, so furtherance of crime or fraud. If the services or advice of the lawyer were sought or obtained to enable or aid anyone to commit or plan to commit what the client knew or reasonably should have known to be a crime or fraud, then definitely the attorney-client privilege will not apply. No, okay. Let's go to the next slide for the explanation. Okay, this is really very obvious. No, we cannot use the attorney-client privilege to shield criminal activity and fraud. No, otherwise the noble profession that it is touted to be will be for naught. No, so this is really self-explanatory. Okay, the second one. The second exception, claimants through the same deceased client as to a communication relevant to an issue between parties who claim to the same deceased client, regardless of whether the claims are by tested or intested or by inter vivos transaction. Let's go to the explanation. Okay, so this happens when there are competing claims of succession. And of course, we know that even the attorney-client privilege survives even death, no? But then in succession cases, it's all important. The objective of every tested case, even in tested succession, is to distribute the estate as soon as possible to those who were intended to benefit from it, right? And so there will be no good served if we use the privileged communication rule to prevent the attorney from disclosing the intentions of the decedent. Okay, let's go to the next exception. The next exception is the breach of duty by the lawyer or the client, no, as to any communication relevant to an issue of breach of duty by the lawyer to his client or by the client to his or her lawyer. Let's go to the next slide for the explanation. Naturally, if there is a suit between the lawyer and the client, let's say the lawyer sues the client for attorney's fees, or the client sues the lawyer for malpractice, then there is a waiver already of that privilege, no? And it is important to open to the courts, no, this privilege communications. Okay, let's go to the next exception. Document attested by the lawyer as a communication relevant to an issue concerning an attested document to which the lawyer is an attesting witness. Let's go to the next slide. This really is not an exception, no, because here the lawyer is not acting as a lawyer, no, in his professional capacity. Rather, the lawyer was acting merely as a witness, no, and so when he took on the role of an attesting witness, he was very well aware that he would be called, or he could be called at any time in the future to testify on the execution of that document, right? So really, this is not technically an exception to this rule, okay? All right, okay, and then this is the last exception on joint clients. As to a communication relevant to a matter of common interest between two or more clients if the communication was made by any of them to a lawyer retained or consulted in common when offered in an action between any of the clients unless they have expressly agreed otherwise. Let's go to the next slide, Attorney Renz. Of course, if you are joint clients, then you have a unity of purpose here, no? Your interests are more or less the same. And so any communication is made with the intent of helping both clients, no? So unless there is an express agreement between them, no, to keep the individual confidences confidential. All right. Okay. So now we go to another introduction of a new revision or a new provision, I should say. No, it has to do with the physician psychotherapist provision. No? Before, this provision only referred to the physician-patient privilege. No, so before, who were covered? Only those persons authorized to practice medicine, surgery, or obstetrics. No, that was the old provision. But now it includes a psychotherapist, no, or a person who is reasonably believed by the patient to be authorized to practice medicine or psychotherapy. Okay, and the all-important addition also here is that it includes the state of a patient's mental or emotional condition, including alcohol or drug addiction. Okay, so of course it still retains the old provision or limitation that it only applies in civil cases. But the other important revision here is that now there is no longer a requirement that it must tend to blacken the reputation of the patient. Okay, let's go to the next slide, Attorney Renz. Okay, so there, who may be considered a psychotherapist for purposes of this provision? First, a person licensed to practice medicine who is engaged in the diagnosis or treatment of mental or emotional conditions. And second, someone who is licensed as a psychologist by the government while similarly engaged. Okay, let's go to the explanation slide. There you go. Okay, so here the rationale, of course, is to encourage the free and unhindered communication between the psychotherapist and the patient, because that is all important for proper diagnosis and treatment, no? And so without this privilege attaching or cloaking all those confidences, there might even be a violation of the constitutional right to privacy, because there can be no more private confidences than those referring to one's own mental or emotional state, right? And so the court deemed it wise to include this in the provision, right? Okay, let's go to the next slide, Attorney Renz. Now we go to what was previously known as uh, the penitent, no, the priest penitent privilege, and from the nomenclature itself, priest penitent, no. So well, it was really biased towards the Catholic tradition, no. So now to remedy that, the court added the other words, no. So now it's called a minister priest, or a person reasonably believed to be so cannot, without consent of the affected person. And here, instead of just the word confession, we're now referring to any communication, okay, which is made between the declarant, no, the one who makes the confidences or the communication, to the minister priest or other person uh, in his professional character. So it's now no longer just anyone who is recognized as a minister or a priest, but any other spiritual advisor also, no? As long as there is some way that course of discipline enjoined by the particular religious group that spiritual advisor belongs to, can be proven in court, okay? So medyo mas naging fair or balanced itong provision natin with the present wording, right? Okay, let's go to the next slide, please, regarding public officers. Okay, so the disqualification by reason of the confidences, a public officer cannot be examined during or after his or her tenure. The Supreme Court added after his or her tenure here. And then look at the second paragraph. The communication shall remain privileged even in the hands of a third person, okay, who may have obtained the information, provided that the original parties to the communication took reasonable precaution. Now, this is just a safeguard, because although the original parties to the communication may have taken all the necessary safeguards or precautions to guard the privileged matter, no, but if someone accidentally comes across a recording or the minutes, or even overhears that privileged communication, then with the inclusion of the second paragraph, now we are also guarding against that, no? Now the next two slides just gives you the requisites for the disqualification to apply, no? This is taken from the case of Neri versus Senate Committee, no? We are all familiar with this case involving the former NEDA chairperson, and so that's for your own reference when you do your personal review. Okay, so let's go to the next one. The next slide. Did we skip a slide, Attorney Renz? Can we go to the preceding slide? Before that, Attorney Renz, can we go to the preceding slide? Oh, okay. Next slide. No. Let's go to the next slide, please. Let's go to the next slide. Okay. Some more. Okay, next. Next, please. Okay, there you have it. Go back, please. One slide. No, go back, please, one slide. The journalist source privilege. Okay, one more. Section 24. There you have it, no? No, please stay with the journalist source privilege, Attorney Renz. No, the one after that. The journalist source privilege, it would have been Section 26, no, in the proposed draft, but the Supreme Court, upon approving, please stay on that slide, please, Attorney Renz. Section 26. There you have it. Okay. This would have been Section 26 of the revised rules, but upon submission to the en banc, the Supreme Court en banc thought of removing Section 26 for the journalist source privilege. And the reason is because we have adequate laws on the matter, no? The latest of which is RA 11458, which you see on your screen, which is actually a shield law no, it extends to journalists and other media practitioners, no, the privilege of keeping in confidence the sources of their news items. All right. Okay. Now we can go to the next slide, please. Other privilege matters before the journalist source privilege, Attorney Renz. There you go. Okay, so those are just a list of other matters that the court has considered privilege in its decisions. No. Okay, let's go now to testimonial privilege, the parental and filial privilege, section 25. Okay, there you have it. Okay, what is the difference between this and the preceding disqualifications? No, the marital disqualification rule. No, here this is a privilege. No, and by its nature, a privilege is something that you can waive. So we have had decisions of the Supreme Court where children have testified for or against another parent. No. And sided with the other parent because the Supreme Court looked at that as a waiver of the privilege. No. All right, but the Supreme Court here added here, except when such testimony is indispensable in a crime against that person or by one parent against the other, the Supreme Court just thought of clarifying. No, this just makes it consistent with the earlier marital disqualification rule. Okay, the next slide, please, Attorney Renz. Okay, so there you have some examples. A stepmother can be compelled, okay, can testify against a stepdaughter because step relationships do not qualify as relationships falling within the direct descendants rule, okay? Right, next. Okay, section 26 is a new provision. It refers to trade secrets. Now, this just institutionalizes what has already been decided repeatedly by the Supreme Court. One of the classic decisions is here on the screen below, Air Philippines versus Penswell. No, so a person cannot be compelled to testify about any trade secret unless the non-disclosure will conceal fraud or otherwise work injustice. When disclosure is directed, the court will take protective measures as the interest of the owner of the trade secret and of the parties and the furtherance of justice may require. So here the judges have to do a balancing act again. On the one hand, you have the property rights of the owner. On the other hand, you have public interest, no, and welfare. So a balancing act for our judges. But the privilege at least is now here in writing, okay? All right, let's go to 3, admissions and confessions. This is just a renumbered provision. No, there is no change except to use gender inclusive language, no? But just the same, for you at the bottom, you have a definition of what an admission is. It's a statement of fact which is made by a party against his interest or unfavorable to the conclusion for which he contends or is inconsistent with facts alleged by him. And to be admissible, you have the requisites there, no? It must involve matters of fact and not of law. It must be categorical and definite. It must be knowingly and voluntarily made. And of course, it must be adverse to the admitter's interest. If not adverse, then it would be nothing but gratuitous statements or self-serving statements. Okay, right, next. Okay, now we go to compromises. Okay, the general rule is that an offer of compromise is not admissible, right? So in civil cases, it's still the same. No, it's not an admission of any liability. But the Supreme Court added this provision, okay? Neither is evidence of conduct nor statements made in compromise negotiations admissible, except evidence otherwise discoverable or offered for another purpose, such as proving bias or prejudice of a witness, negativing a contention of undue delay, or proving an effort to obstruct a criminal investigation or prosecution, no? So this insertion really refers to ADR, okay? Because we all know that in civil cases, that we have mandatory mediation, we have court annex mediation, no, for civil cases. And then we also have JDR, judicial dispute resolution. And so in the respective rules of CAM and JDR, confidentiality, of course, is a strict rule, no, to be followed by the judges and all the participants in the mediation and the JDR. But just including this here makes it all comprehensive and consistent with each other, okay? Now, in criminal cases, except those involving quasi offenses and those allowed by law to be compromised. Next slide, Attorney Renz, no? the offer of compromise may be received as evidence of guilt, no, as an implied admission of guilt. But then the Supreme Court also added a phrase regarding plea bargaining, also in acknowledgement of the fact that plea bargaining is a form of mediation or compromise, which should be covered by the rule of confidentiality. And that is why it states here, neither is any statement made in the course of plea bargaining with a prosecution which does not result in a plea of guilty or which results in a plea of guilty later withdrawn admissible. Okay, so that is the rule now. Now, just for clarity, let's go to the next slide, Attorney Renz. I made a summary for you. Okay, so offer of compromise in civil cases, it's not admissible as an admission of any liability. Second, it is admissible for other purposes, okay? To prove bias of a witness or to negate undue delay. For example, there's the charge of non-prosecutor or failure to prosecute within a reasonable period of time. No, you can use that. No, that well, there we had mediation, we had discussions of compromise, etc. Okay, and then to prove obstruction of criminal investigation or criminal prosecution. Okay, now, but the rule is not absolute according to Supreme Court decisions, right? No. So, for example, if the party denies the existence of a debt, let's say it's a case for sum of money, the party denies the existence of a debt, but offers to pay, not just to buy peace. The party does not want, the defendant does not want the litigation to drag on. No, it's such a hassle for the defendant. So he offers to pay, but not to admit liability, just to buy peace. Okay, so the offer of settlement is inadmissible. Okay, there is no admission of guilt or liability there. But if in the course of the discussions between the parties, the defendant admits the indebtedness and even offers to settle, no, let's say, okay, can I pay it in three monthly installments instead of lump sum? No, then that can be introduced as proof of admission of liability. Okay, let's go to the next slide, Attorney Renz. Now let's go to criminal cases. Now, in criminal cases, except quasi offenses and those allowed to be compromised, no, the offer of compromise is admissible as an implied admission of guilt. Okay, but it is inadmissible if the plea of guilt is withdrawn. Okay, well, that goes to follow, right? The plea of guilt was withdrawn, so you cannot hold him to it anymore, no? Or if there is an offer of plea of guilt to a lesser offense during plea bargain, but the offer is not accepted by the prosecution or by the complainant, then it's also inadmissible. If there is also a statement made during the plea bargain and no plea of guilt results or the plea is later withdrawn, then likewise it is inadmissible. Okay. Now in this case of San Miguel versus Calalo, Attorney Renz, can we go back there? There was an offer in writing, no, from the accused, no. At that time, they were still undergoing preliminary investigation, no, before the fiscal's office. This was for violation of BP 22. No, and the respondent in the preliminary investigation wrote a letter to San Miguel asking for a compromise and offering to pay by installments. No, but nothing came of it. And then the information was filed in court, and now that letter was sought to be introduced against the now accused. No, and the Supreme Court said no, you cannot consider that as an implied admission of guilt because that was not in the context, no, of a criminal prosecution already, because it happened even before the filing of the criminal complaint. Okay. Now the second case refers to, I think this was a murder charge, no, where the accused, while already in detention, wrote letters to the brother of the deceased, no, asking for forgiveness, asking for forgiveness for what he had done for killing the brother, no? And the court, of course, took that as an admission of guilt. Okay, let's go to the next slide. All right, this is just a renumbered provision, admission by third party. Next, Section 30. Okay, it was also renumbered, but now there is an insertion of the word authorized, no? Just for clarity also, although that is already clear from the decisions of the Supreme Court on this matter, but just to make it clear, no, it's just stylistic. These changes are stylistic in nature. Okay, let's go to the next one. Admission by conspirator. Also, just for clarity, the Supreme Court added the phrase in furtherance of the conspiracy. We changed relating to the conspiracy to in furtherance of the conspiracy because we wanted to be very, very objective, no? That the act or declaration must be in furtherance of the conspiracy. It must not only relate to it in a tangential way, but it must be directly towards furthering the conspiracy. And that is why the Supreme Court thought of revising this provision, no? Okay, and then you have an example at the bottom, the case of Salapuddin versus Court of Appeals. This involved the bombing of the Batasan complex, no, where former Congressman Salapuddin was implicated. So let's go to the next slide. Admission by privies, again, just for clarity and stylistic change there, right? Let's go to the next one. Also, just a renumbered provision, and we have gender inclusive language added also. Admission by silence. Of course, the doctrine here is the natural instinct of a human being, if he or she is charged unfairly or unjustly, is to defend himself or herself, no? And so if you are silent, then the presumption that arises is that you are probably liable or guilty, okay? Next. Then we have confession, also renumbered, and then we have gender inclusive language there. Okay, so I have, again, the case of Salapuddin, where you have the requisites, no, for establishing conspiracy by other evidence, not than the extrajudicial confession. All right, let's go to the next slide. Now we have previous conduct as evidence, no? So these are just renumbered provisions. Section 35 now is similar acts as evidence, and Section 36 is the unaccepted offer. We go to the next slide. Let's explain similar acts or previous conduct. This is the previous conduct rule, no? So evidence that one did a certain thing at one time is not admissible to prove that he did the same or similar thing at another time. That's the rule, no? That's the previous conduct rule. Okay, so you have examples here. You have the Metrobank case, no, where you have she was a cashier, no, and there was a shortage in the bank's I think cash tally for the day, and the employer the bank sought to introduce evidence of a prior shortage where the same teller or cashier was involved in a different branch of the bank, no? The Supreme Court said no, that a shortage also occurred when she was employed in another branch of the bank does not necessarily mean that she is guilty of either shortage, no, the first or the second. Plus, the court also emphasized that the employer here did not take any sanctions or did not impose any sanctions, no, against the employee. In fact, even retained her as a cashier, no, in that sensitive position. And so the court said definitely that previous conduct cannot be invoked against her, right? Okay, next slide. Okay, now we go to the all-important counterpart provision of our provision earlier on the lack of first-hand knowledge rule, no? So this now is the new hearsay provision. Okay, so please, just to repeat, now when the witness is testifying on a matter not based on his or her own personal knowledge, we call that the lack of first-hand knowledge, okay? We don't call it hearsay. What we call hearsay now is this, Section 37. Let's go through this together, okay? Hearsay is a statement other than one made by the declarant while testifying at a trial or hearing, offered to prove the truth of the facts asserted therein, okay? So what's important to remember? Hearsay is any statement by a witness outside of court, okay, or outside of a trial or a hearing. If I am a witness, everything that I say outside this particular case or litigation is hearsay. Okay, that's simply putting it, all right? Now, a statement, what is a statement? Okay, a statement is any oral or written assertion, or it can be, number two, a non-verbal conduct, okay, which is intended to be an assertion, okay? So the rule is hearsay is inadmissible except as otherwise provided, right? Okay, let's go to the second paragraph. A statement is not hearsay if the declarant testifies at the trial or hearing, okay, so when is it not hearsay? If the declarant testifies at the trial or hearing, so in my example, I am the witness, I am testifying now, okay, and I am subjected to cross-examination. Okay, but not as to any of my out-of-court statements. No, there is a limit. You can only be subjected to cross-examination on 3 matters. Okay, the first one, any statement inconsistent with the declarant's testimony and given under oath, subject to the penalty of perjury at a trial, hearing, or other proceeding, or in a deposition. Letter B, consistent with the declarant's testimony and is offered to rebut an express or implied charge against the declarant of recent fabrication or improper influence or motive. Or letter C, one of identification of a person made after perceiving him or her. Okay, let's go to the next slide now, to the explanation. Okay, all right. So just to emphasize, what is the new hearsay rule? Hearsay now is any out-of-court statement, okay, made by a witness declarant. Okay, so the Supreme Court refers to this witness declarant as an at-trial witness. Okay, so we're talking about a particular trial, okay, and the witness in that particular trial is called an at-trial witness or the witness declarant. Now, this witness in this trial made statements out of court. All those other statements are what is now referred to as hearsay. Okay, so that's clear. Okay, now what are these statements that are covered? And as already mentioned, they are either oral or written assertions or conduct which is intended to be an assertion. For example, nodding your head while being questioned or shaking your head to signify that you're not in agreement, that can be conduct intended to be an assertion. All right. Okay, so what are the exceptions? Let's go through the exceptions one by one. Okay, but first, remember, okay? So this is what you need to remember. It must be, the witness must be in court, okay? The witness is subject to cross-examination, no? And the witness is subjected to cross-examination only on 3 matters, all right? The first one is a prior inconsistent statement under oath at a trial, hearing, or other proceeding, or in a deposition, okay? Whether to impeach the witness declarant or also to offer it as substantive proof. Okay, let's stay with this. Okay, why prior inconsistent statements only? Why cannot I introduce prior consistent statements under oath at a prior trial? Diba? That's corroborative, correct? Well, the reason precisely to limiting it to prior inconsistent statements is because we don't want to flood that trial with repetitive evidence of similar statements, right? So you have this habit of lawyers who present or mark all these TSNs or affidavits executed in related proceedings, no? But they are just really corroborative, no? If the witness, no, under oath in this particular litigation has already stated it to the court, no, what is more weightier? I mean, what is weightier than that? I'm sorry, no, presenting a prior affidavit executed by the witness saying the same thing is not going to add anything to it because the witness already declared it face to face with the court, right, under oath. So that is the reason why the Supreme Court is limiting this to prior inconsistent statements. Okay, now let's go to the second exception. Prior consistent statements. Here we have consistent statements, but only to rebut an express or implied charge against the declarant of recent fabrication or improper influence or motive. Okay, so we are limiting this for the same reason that I already gave, no? And the only time that you can use a prior consistent statement is to rebut an express or implied charge against the declarant of recent fabrication. For example, okay, in this litigation, I am saying that I do not owe you anything. I already paid you. Okay, so now my adversary denies that and says you are stating a falsehood. You have not paid me. Okay, so now you can introduce prior consistent statements that I have made to rebut that charge that I am stating a falsehood or that my denial of liability is a falsehood. Okay, so that is exception number 2. And then the third exception is identification of a person made after perceiving the person. All right, why did the Supreme Court thought of including this? No, well, we all know, we are all aware of how long litigations take us. No, well, of course, with the reforms instituted, especially with the continuous trial, we've gone a long way in trying to address this problem. No, but still, no, if an incident or a felony occurs today, and I make an identification of a person as a witness, let's say I make that identification to the police immediately after the incident by giving a statement, okay? But then I'm called to testify in court 3 years later, right? So now you can use my prior statement out of court, no, of identifying the assailant, no, and it should get more credit because the identification was made nearer to the time of the occurrence rather than my in-court identification, which is happening 3 years later, right? Okay, so that is very important for us, and that is why the Supreme Court deemed to include the third exception. All right. Okay. So let's go to the next slide, Attorney Renz. So I hope that that is clear now. No, the new concept of hearsay. Not really hard to understand. It's just that we're shifting radically from what we always knew. No, so we are moving out of that. We are moving out of that comfort zone, and we have to embrace this new concept of hearsay. All right. Okay. So now we go to the exceptions to the hearsay rule. First one is dying declaration, of course, the dead man statute. Okay, no change here except for gender inclusivity. So you have the requisites there. I've identified it for you. You can look at it at your leisure. Okay, let's go to the next exception. Okay, statement of decedent or person of unsound mind. Okay, again, the court here, some stylistic changes for clarity. So inserted the phrase for a party or a signer of a party or a person in whose behalf a case is prosecuted, okay? Just for clarity, no? And for guidance. Right. Okay. And then the last paragraph or the last statement there is any statement of the deceased or the person of unsound mind may be received in evidence if the statement was made upon the personal knowledge of the deceased or the person of unsound mind at the time when the matter had been recently perceived by him or her, and while his or her recollection was clear. No? Such statement, however, is inadmissible if made under circumstances indicating its lack of trustworthiness. No? So you see, all these exceptions to the hearsay rule, they have one underlying condition, no? Reliability or trustworthiness. No? So yun ang lagi nang hahanapin ng judges, no? When you're introducing statements like this. So what is the badge of credence of this particular statement or declaration? No? Kasi this is hard because the person has already passed away or the person is already of unsound mind. No? So you have to establish that at the time the statement was made, no, the person had personal knowledge of what he was stating, or the person of unsound mind was still in full possession of his mental faculties. Okay, let's go to the next slide. Declaration against interest, no? Also, some changes for gender inclusivity. And then the last statement there, a statement tending to expose the declarant to criminal liability and offered to exculpate the accused is not admissible unless corroborating circumstances clearly indicate the trustworthiness of the statement. No, the Supreme Court thought it best to put this here, although it's already in jurisprudence repeatedly enunciated by the Supreme Court, because we don't want parents or spouses or children making declarations or admitting guilt, no, or liability for something just to protect their loved ones, no? And so that is the reason why this was added by the Supreme Court, okay? Right, so the next slide shows you the distinction between a declaration against interest and an admission against interest, no? And of course, it's a matter of privity, no? In declaration against interest, it is made by a person who is neither a party nor in privity with a party to the suit. And it is admissible only when the declarant is unavailable as a witness, no? That is why it's an exception to the hearsay rule. Now, an admission against interest is made by a party to a litigation or by one in privity with or identified in legal interest with such party and is admissible whether or not the declarant is available as a witness, right? Let's go to the next slide. Now we have the provisions on pedigree. No, the important revision here is we added adoption, the word adoption. So now we have officially recognized adoptive relationships, no, as part of this provision. This is just to be consistent with the effects of adoption, diba? Okay, so we have adoption there, and then of course we have that clarificatory phrase in the absence thereof. with whose family he or she was so intimately associated as to be likely to have accurate information concerning his or her pedigree. This was thought to be necessary, no, for inclusion, because most of our cases actually about pedigree, the declarations come from people who are not related, whether by blood or marriage or even by adoption, no. So like long time house help, or the ones who took care of the concerned individuals. Okay, let's go to the next slide. Okay, so this is the same one. No, let's go to the elements, right? Okay, so you have there the elements, and I already added adoption and the person with whose family he was so intimately associated, no? And you have an example there in the case of Nepomuceno versus Lopez, right? Okay, let's go to the next slide, section 42. Okay, still pedigree. Again, the word adoption was added. Let's go to the next slide for the requisites. Okay, there you have the requisites, no? A statement by a member of the family, either by consanguinity, affinity, or adoption. The statement is about the reputation or tradition of the family in respect to the pedigree of any member of the family. And letter C, the reputation or tradition is one existing previous to the controversy. Okay. Okay, let's go to the next slide, Attorney Renz. Common reputation. Okay, here there is an important change, no? If you look at the old provision, it refers to facts of public or general interest more than 30 years old, no? So that is what is referred to as the requirement of antiquity. Okay, but now the Supreme Court has done away with that, no? And instead, it included this passage, no, as to boundaries of or customs affecting lands in the community and reputation as to events of general history important to the community. Okay, why is that important? Now the Supreme Court has emphasized more the consensus of the community. No, so history through the consensus of the community. Okay, and not antiquity, not the passage of time, because even if you say that it is 30 years old, no, but the residents in the community have changed repeatedly over that 30 years, no, where is the reliability, diba, as to the history or the consensus. Okay, so that is actually a very logical change. Okay, next we have res gestae. Okay, so another exception to the hearsay rule, no? So here, no important change, no substantial change, but the court thought of including the all-important element as part of the provision itself by adding the phrase under the stress of excitement caused by the occurrence. Okay, so we all know that res gestae refers to a startling occurrence or declarations made under the hold of a startling occurrence, and that is why the Supreme Court thought of adding that in the provision. No, if you go to the next slide, Attorney Renz will be able to show them the requisites for the application of res gestae. The important thing here is that there be no time for the declarant to reflect or to concoct a falsehood, no? So because you are still overtaken by the startling occurrence, no, you are still in the hold of the startling occurrence, you have no time to invent a lie or to invent a falsehood or a false story. That is the very essence of res gestae, no? And in the slide after the requisites, okay, you also have some tests there at the bottom, but in the next slide you'll see the guidelines, no, for determining spontaneity, because it's supposed to be a spontaneous declaration which is impelled by the startling occurrence, no? That is the badge of truthfulness there. So how do you determine spontaneity? Well, the principal factor, of course, is time lapse, no? Like if it happened like a day ago or 2 days ago or a week ago, then naturally the declarant would have had many opportunities to go over what happened, to reflect on it, and also to probably add or supply his account of it, no? But there is no fixed time that the Supreme Court has set, okay? Because in its own decisions, sometimes a difference of just a couple of hours has been thought as as already barring the application of the exclusion or exemption. But sometimes even days have passed. No, like I know of cases where 2 days have passed, but the Supreme Court still considered that the doctrine of rest stay was applicable. So time is an important factor, but it is not the only factor. Okay. The second would be the place where the statement is made. The third, the condition of the declarant when the utterance is given, because you will see, no, physically, emotionally, if the startling occurrence still has a hold on the declarant. And then fourth, you have presence or absence of intervening events between occurrence and the statement. And then the last one is the nature and the circumstances of the statement itself. Okay, let's go to the next slide, Attorney Renz. Okay, now you have records of regularly conducted business activity. This is important, no? For judges, you should welcome this change, no? More often than not, we have witnesses who are testifying on the basis of records, no? For example, those from financial institutions, no? They constantly change the account officers or the credit officers, and so the ones who come to court are not the ones who prepared the documents. They're not the ones who recorded the transactions. They're not the ones who witnessed the execution of the promissory notes, etc., etc. And so their testimonies are only based on the documents in their possession, and they're always objected to for lack of personal knowledge, right? Okay, so this is the provision: records of regularly conducted business activity, a memorandum, report, record, or data compilation of acts, events, conditions, opinions, or diagnosis made by writing, typing, electronic, optical, or other similar means at or near the time of or from transmission or supply of information by a person with knowledge thereof. So it's still important that the one who made the entries, okay, had personal knowledge. Okay, that is important. Okay, and kept in the regular course or conduct of the business activity. And such was the regular practice to make that memorandum, report, record, etc. No, all of which are shown by the testimony of the custodian. Okay, now we're speaking of the custodian who's testifying in court. Okay, or other qualified witness. So we are exempting that from the hearsay rule. Okay, right. Okay, so we go to the next slide. That's just an explanation. Okay, you have there the things that must be established to avail of this exception. And please remember that under the new section 45, the requirement that the entrant must be dead or unable to testify is no longer applicable, no? Kasi dati, lahat ng exceptions natin sa hearsay rule, mostly binebase natin doon that the witness is unavailable, the declarant is unavailable to testify, whether he's dead or otherwise outside of the jurisdiction. No? But not anymore. Okay. Next, let's go to section 46. The new section 46 was renumbered and only gender inclusive language was included, no? Entries in official records. Next slide shows you the requisites, no, for the application of this particular exception. The classic example would be a traffic accident investigation report, okay, which is largely considered by the court as hearsay, as based on hearsay, no? The traditional concept of hearsay. Okay, now no more, no? Now we say lack of first-hand knowledge because the traffic investigator goes to the scene of the vehicular collision when everything is finished already. Okay, the collision has already occurred, and he just gets, you know, statements from people around him. So that's the classic definition of an independently relevant statement also, no? The traffic investigator has personal knowledge of what all these witnesses told him, okay? But he does not have personal knowledge of how the accident occurred, all right? Okay, next. Okay, commercial lists, okay. Just a renumbered provision. The next one also is a renumbered provision. Okay, I have some examples at the bottom. Okay. And then we have section 49, testimony or deposition in a former proceeding. Okay, so the testimony or deposition of a witness deceased or out of the Philippines or who cannot with due diligence be found therein or is unavailable or otherwise unable to testify. Okay, so why did the Supreme Court add these provisions, this passage? No, so before it was just the testimony of a witness who was deceased or unable to testify. Okay, the Supreme Court thought of adding these details, no, because this has been a cause of great delay. because the witness is not dead, no, the phrase unable to testify is quite vague, no? Should it be unable to testify through no fault of the party presenting, or unable to testify through no fault of that intended witness, no? So the Supreme Court thought of adding these clarifications because the witness is out of the Philippines, or the witness cannot with due diligence be found, or is otherwise unavailable or unable to testify, maybe because of medical reasons. No, so that's the revision here. Okay, so the next slide will show you some rules, no, regarding the admissibility of former testimony, and of course the requisites are there, no, also, and some jurisprudence for you to look at your own leisure. Okay, now let's go to the last provision on hearsay. The last exception is what we call a residual exception. It's a catch-all exception. So far, we have 11 exceptions to the hearsay rule, no? You may think that's a lot, no? But in the US, they have, I think, 27. So the Supreme Court thought of adding a residual exception. This is to provide for future exceptions, which they may not have thought of as yet, or which may not have figured in any of the decisions that they have handed down so far. So we have a residual exception here. And it states that a statement not specifically covered by any of the foregoing exceptions, having equivalent circumstantial guarantees of trustworthiness, will be admissible if the court determines, first, that the statement is offered as evidence of a material fact. Second, the statement is more probative on the point for which it is offered than any other evidence which the proponent can procure through reasonable efforts. And third, the general purposes of the rules and the interest of justice will be best served by admission of that statement into evidence. Okay? But the condition is in the second, or in the last part of this provision. What are the conditions for such admission? Now, the statement may not be admitted unless, no, the proponent makes known to the adverse party sufficiently in advance of the hearing or by the pretrial stage to provide the adverse party with a fair opportunity to prepare to meet it, no? The proponent's intention to offer the statement and the particulars should already be, including the name and address of the declarant, should already be given to the adversary. No? So that's just a guarantee of due process. Okay, we don't want to hold our litigation or our trial so-called in the dark. No? All right, let's go to the next slide to explain our new provision. Okay, so as I mentioned, this is a catch-all exception, and this is taken from the Federal Rules of Evidence. No. So the Supreme Court just wants to ensure that the judges are given sufficient leeway to accept exceptions to the hearsay rule, no, which are not covered by the exceptions now found in the rules. Okay, let's go to the next slide, please. Opinion. Okay, now we go to the opinion rule, no. Section 48, which states that the opinion of a witness is not admissible except as indicated in the following sections, no. It's just renumbered. No changes, it's now section 51. That's a general rule, okay? Now, what are the exceptions? Two known exceptions: the opinion of an expert witness, and second, the opinion of an ordinary witness. Now, the general misconception is that the opinion of an ordinary witness is inadmissible, no? It's generally inadmissible, but there are exceptions, okay? And the exceptions are found in section 53, okay? We'll look at the opinion of expert witnesses first. Now, section 52 states that the opinion of a witness, can we go to the provision first, Attorney Renz, the preceding slide, section 52, there you go. There is no change there except to insert the word education. The Supreme Court thought of adding the word education. We already have special knowledge, skill, experience, or training, but the court thought of adding education. Okay, so now it's there. Now, as far as the opinion of ordinary witnesses, there is no change except for gender-inclusive language, all right? Let's go to the next slide now, and let's show them what are these requirements for admissibility, okay? So the opinion of an ordinary witness, we'll start with an ordinary witness first, no? Is admissible only in 3 occasions, okay? If it is for the purpose of identifying a person about whom he has adequate knowledge, okay? So identification of a person. Second, if it is to identify a handwriting with which he has sufficient familiarity, okay? Second. Third, if it is about the mental sanity or the mental state of a person with whom he or she is sufficiently acquainted. Okay. Now, I added a fourth, which you find in the provision also. An ordinary witness may also testify on his impressions. No, so although they did not call it opinion, they called it impressions. No, his or her impressions of the emotion, behavior, condition, or appearance of a person. And why is that? I don't think it's opinion really. It's part of first-hand knowledge, di ba? I'm testifying as to my perceptions, right? An impression is a perception. So it should not really be here under opinion. It should be part of personal knowledge or first-hand knowledge, okay? And then let's go to the admission of the opinion of an expert, no? It must be an expert, no? The presentation of an expert witness is always problematic. In my 11 years as a trial court judge, no, every time an expert witness is going to be presented before me, we always had to go, I insisted, no, that there is a two-part process, no, to the presentation of an expert witness. The first part is the qualification stage, no? You have to qualify your expert first, no, as an expert. And the court must accept him as an expert, right? Before you proceed to the second part, which is the examination proper, okay? So largely, hindi ginagawa or hindi na-observe. Magdadala lang ng CV or resume, ibibigay dun sa kalaban, but the courts do not go through the process of qualifying, no? Hindi nasasabi, I tender this person as a witness in what field? Sinasabi lang, I tender this witness as an expert in the field of science. What science? Science has many fields, no? So hindi dapat ganon. We have to be very, very, very specific, okay? And so I guess that's the reason why the Supreme Court added the word knowledge, no? So now you have to show that your expert has the required professional knowledge, learning, skill, training, etc. in the subject field of inquiry, no? Sufficient to qualify him as an authority, okay? And then that he is familiar with the standards required of a professional under the circumstances, no? So we have to observe both the qualification stage and the actual examination stage with regard to the presentation of an expert witness, okay? So at the bottom, I placed in bold letters, no, this statement, reasonable measure of reliability. The broad latitude is given to the judge, no? But what are we looking for in the end? Always the measure of reliability. Can I rely on this person's opinion, no? And the reason why we call him an expert, you should be convinced. You're the judge. You should be convinced he must really be an expert, not just because of what he studied, but because of how he has applied what he has studied, no? Through the numerous examinations or through the numerous surgeries or other medical procedures that he has performed, applying his knowledge, no? So all those things will go into the measure of reliability. And you know, it's difficult for judges. We are skilled or knowledgeable about the law, but in most other things we are next to ignorant, no? So we are laymen, okay? So we have to rely on an expert with regard to his field of expertise. So you have to guard against complete dependence, no? So you have to also be wary about immediately accepting somebody as an expert unless you have tested the reliability of his expertise, okay? Okay, let's go to the next slide. Okay, now we go to character evidence. No, character evidence, generally not admissible, okay? So I will skip the provisions and I will just go to the summary because that will make it all clearer for you. Okay, anyway, you can go through the provision and all the underlined parts of the provisions are the revisions, okay? Let's go to the summary, Attorney Renz, that I prepared on character evidence. Go ahead, there you go, okay. So what is our general rule when it comes to character evidence? It is inadmissible, okay? Why? Because we don't want to deflect the focus of the trial and of the judge, no, from the real issues, okay? Character evidence is always controversial. Character evidence is always interesting, di ba? So mas gusto natin, yun na lang pag-usapan natin. But that should not be the focus if that is not the issue of the case. So it is the circumstantial use of character evidence that we are trying to limit or restrict because we don't want the issues to be confused. If the issue is the violation or breach of a contract, the character of the party should not be at issue, no, or it should not confuse the real issues. Okay, so why is it prohibited? As I said, it's because of the circumstantial use of the evidence to confuse, no. But there are certain exceptions when character evidence is admissible. Let's start with criminal cases. Okay, for example, the accused may prove his or her moral trait which is pertinent to the charge. Okay, for instance, in offenses involving moral turpitude, let's say estafa, no. By the way, as a general rule, any offense that involves deceit or falsehood, no, or deceit or falsehood, that is an offense involving moral turpitude. Okay, so let's say in the charge for estafa, no, the accused wants to introduce evidence that he is a church leader. Okay, he occupies an important position in their parish, or like he has been awarded as outstanding or ulirang ina or ulirang ama by some social civic organization. Okay, so that is admissible, no, because it's pertinent to the charge that which has an element of deceit, no. So it goes into his reputation of having a good moral character. Okay, but if he does that, if the accused does that, then the prosecution on rebuttal now may prove his bad moral character. Okay, so in criminal cases, it is up to the accused. Okay, if the accused does not want to touch on his moral character, then the prosecution in no instance can introduce, okay, evidence of the bad moral character of the accused. But if the accused opens the gate because he or she introduces evidence on his moral trait, which is pertinent to the charge, then the prosecution on rebuttal can now present evidence of the accused's bad moral character. Okay? Right. Now, the offended party. Can the offended party present character evidence? The offended party can present character if it tends to establish the probability or improbability of the charge. Okay, so, well, for example, slander by deed or unjust vexation, no? The offended party, the accused says that, no, it's actually the offended party kasi the offended party is known in our community as, starting many fights, having many quarrels, etc. So the offended party can now present character evidence to establish the improbability of the charge or the probability of the charge. Okay, let's go to the next slide. Civil cases, right? Civil cases, only when the moral character of party is pertinent to the issue of character involved, no? So that is the only time when character evidence is admissible in a civil case. Let's say it's a case for damages based on a vehicular accident or a collision, no? So the issue is recklessness, no? The moral character of the party for being reckless or imprudent is pertinent to the issue here, no? So the introduction of character evidence is admissible, no? Okay. Now, there is a third instance. So we talked about criminal cases for both the accused and the offended party. We talked about civil cases, no? And now we're talking about the third instance, which is the character of a witness, okay? Now you have to read this in relation to Rule 132, Section 12, no? Which is impeachment by evidence of conviction that applies only to witnesses, okay? In a litigation, okay? So here in this particular provision, it says that the good character of a witness may only be proven after the witness's character has been impeached. Okay, so if you're a witness, you're supposed to be insulated from this. Okay, but to impeach you under Rule 132, Section 12, evidence of a prior conviction may be introduced. Okay, if that is done, then you, the witness, can have evidence of your good character introduced by the party proponent, the party who called you as a witness, no? Okay, and then at the bottom of the slide, you see the methods, how we prove character evidence, okay? And of course, 1 and 2, I think, should be only one, no? So the first says testimony on reputation, okay? This is the traditional form. Because what is character actually, no? It's something intangible, no? So when you say a person has good moral character, it largely depends on his or her reputation in the community, right? So it's testimony on reputation. Now, second says it's testimony in the form of an opinion. Because if I'm the witness and I'm saying that the accused has good moral character, that's my opinion of him. Or that may be the opinion or consensus in our community, which I am voicing out for our community, right? Okay, previously that was not allowed, but now it is recognized as testimony and reputation and is an opinion, all right? And then third, on cross-examination only, the character witness may be asked about relevant prior specific conduct, okay? And now I'm referring to Rule 132, Section 12, prior convictions, no, for criminal offenses, no, and for the purpose of testing knowledge and credibility of that witness. Okay, let's go to the next slide, please. Now we go to Rule 131, burden of proof, burden of evidence, and presumptions. Okay. Now, traditionally, this provision was known as burden of proof and presumptions, no, because you know that if a presumption operates, especially if it's a conclusive presumption, then you do away with the presentation of proof, right, or evidence, no. But here, let's go to the provision, no. So no problem. Same definition of burden of proof as duty of a party to present evidence, no. But then there's an addition. It says burden of proof never shifts. Correct, no. In a civil case, it's the plaintiff. In a criminal case, it's the prosecution. Okay. And in an administrative case, it's always the one who filed the complaint. Okay. Now, the burden of evidence is defined in the second paragraph. This is very new. Okay, or this is new. Okay, this is a revision. Burden of evidence is the duty of a party to present evidence sufficient to establish or rebut a fact in issue to establish a prima facie case. Burden of evidence may shift from one party to the other in the course of the proceedings. Okay, depending on the exigencies of the case. So as opposed to the burden of proof, which never shifts, burden of evidence will shift from one party to the other. Okay, let's go to the next slide. Okay, so there, just as an emphasis, even before, we already had these concepts around, we knew about them. They are repeatedly enunciated in jurisprudence, but now they are, well, now it's in the rules of court, no? So there you just have the definitions of burden of proof and burden of evidence. Just to be simple or plain about it, burden of evidence simply means the burden of proving a fact in issue. Okay? So yung burden of proof, yun yung entirety. Okay? Sino ang kailangang may patunayan sa kasong ito? That's the burden of proof. That's the standard that you have to discharge. Okay? You have to come up to this standard, this level. If you don't reach this level, even if you prove certain facts, then you still don't win your case. But the burden of evidence, for example, in a criminal case, there are 3 elements to establish the offense. You prove element 1, you still proceed to the next element, and then you proceed to the last element. That's the burden of evidence, from fact to fact to fact, which will all add up and then will be totaled. For the court to assess whether through discharging your burden of evidence, you have established the burden of proof. Okay, right. Let's go to the next slide, please. Okay, then we have the presumptions. No changes here except for gender inclusive language. Okay, so you have, of course, the presumptions there. And then the next slide will give you examples only of those presumptions. Okay, and then let's go to the disputable presumptions. Section 3, also no changes. Okay, the only changes are for gender inclusiveness, so we will not discuss them. Okay, so we can I gave you examples from juries just for your own reference also, so you can go through them at your own leisure. Okay, then section 4, just to underscore the most important presumption about the presumption of legitimacy if one is born in wedlock, no? Okay. Now let's go to the new provision under Section 5. There you have it. And Section 6 as well. Okay. The Supreme Court has established new presumptions, no? In Section 5, actually, these are not presumptions, no? So you will see that these are more directive, no, in terms of how to further conduct your litigation. Okay. So in section 5, it says presumptions in actions and proceedings in all civil actions and proceedings not otherwise provided for by the law or the rules. A presumption imposes on the party against whom it is directed the burden of going forward with evidence or to rebut or meet the presumption. Ito na yung tinatawag natin na shifting in the burden of evidence. Okay? So let's say it's a civil case, no? And I am the plaintiff, so I have the burden of proof. But I have a presumption operating in my favor. For example, the presumption is that private transactions have been regular, okay, and that everyone will exercise diligence, no, in protecting one's rights in private transactions, okay, in the ordinary course of business. Now, because of those presumptions, the burden of evidence shifts to the defendant. You have to prove that the ordinary course of business was not followed in this particular instance, no, contrary to the presumption which operates in the plaintiff's favor. That is called shifting of the burden of evidence. So this first paragraph is a directive, no? What do you do when the burden of evidence shifts? Meaning, when a presumption operates against you, what should you do? Okay? The instruction is you must go forward and rebut the presumption. Okay? Otherwise, you lose. All right? Next. The next paragraph. If presumptions are inconsistent, the presumption that is founded upon weightier considerations of policy shall apply. If considerations of policy are of equal weight, then neither presumption applies, meaning they cancel out each other. All right? So you weigh conflicting presumptions. This is a task for the judges. Okay? So if you have two presumptions, no, operating against each other, you have to weigh both, no, and ask yourselves which have weightier public policy considerations, no, operating in its favor, right? Okay, and then let's go to the presumption against the accused in criminal cases, all right? If a presumed fact that establishes guilt is an element of the offense charged or negates a defense, okay? Remember, we're talking about a presumed fact, okay? It establishes guilt, and it is either an element of the offense, okay, or it negates a defense. The existence of the basic fact must be proved beyond reasonable doubt. And the presumed fact follows only from the basic fact beyond reasonable doubt. No? And this is only fair because you have the constitutional guarantee of innocence. You cannot convict an accused on the basis of a mere presumption, right? Okay, let's go to the next slide, Attorney Renz. To explain the new Section 5, no, it was taken by the Supreme Court from a provision of the Federal Rules on Evidence, no, and it's called the bursting bubble approach. No, why the bursting bubble approach? Because it says that a presumption disappears when sufficient counterproof is introduced, no, to rebut it. So kaya bursting bubble. Yung bubble mo that protects you because there is a presumption operating in your favor na burst na kasi sufficient countervailing evidence has been introduced to rebut it, okay? And then let's go to the next slide, Attorney Renz. Okay, as for Section 6, as I already mentioned, it is designed to deal with the situation in a criminal case where the prosecution relies solely upon a presumption to establish guilt or the element of a crime and not any other evidence, okay? So the court cannot convict an accused, no, on the basis of a mere presumption. And that is why the court thought of adding that, okay? Now let's go to Rule 132, the presentation of evidence. Okay, next slide. Okay, examination of witnesses, proceedings to be recorded. No changes there except for gender-inclusive language, all right? And then you also have the rights and obligations of a witness under Section 3. Still the same, okay? No changes. Next slide. At the bottom of the next slide, please. You just have a definition there, or jurisprudence rather, on the duty of lawyers to not to badger witnesses, and also the duty of the court to protect witnesses, okay? Okay, now let's go to Section 5, direct examination and cross-examination. No change in direct examination, but a very substantive change that will affect the way that we conduct trials is found in Section 6 on cross-examination. No? Now, cross-examinations are no longer limited to matters relevant to the direct, no? Or stated in the direct examination or anything connected therewith. That is the former formulation found in Section 6, no? Because in the present Section 6, no, the Supreme Court used the phrase cross-examination on any relevant matter. Okay, that is the substantive change here. Why is that substantive? Okay, right. Okay, so let's go to the next slide, Attorney Renz. Okay, so the Supreme Court in this revision deleted the phrase as to any matter stated in the direct examination or connected therewith, and replaced it with the phrase on any relevant matter. This is a significant shift from the former American rule that we were using, which is the scope of direct rule, which limited cross-examinations to matters taken up during the direct examination or anything connected therewith. And now we are employing the English rule, or what we call the wide open rule. It permits cross-examination on any relevant matter. The only limitation is relevance, okay? So even if not discussed in the direct examination, as long as it is relevant, then the wide open rule allows cross-examination, no? And why did the Supreme Court thought of adopting this, no? Kasi what is evidence after all? No, Rule 128, Section 1 tells us that evidence is the means of ascertaining the truth respecting a matter of fact, no? Now, if we know that the witness who is on the witness stand knows of his own personal knowledge something about the fact and issue, but it was cleverly not touched upon in the direct examination, why should we prevent a cross-examination on that all-important matter just because of the scope of direct rule, the old rule that we had, no? So that is inconsistent with the goal of ascertaining the truth. And that is why the wide open rule has been adopted by the Supreme Court. Okay, so please remember this. The only guarantee or safeguard is relevance. Other than that, then cross-examination is free, no? On all relevant matters. Okay, let's go to the next slide, Attorney Renz. Redirect examination, no changes except for gender-inclusive language. As with recross-examination, Section 8 also. And then we go to Section 10, leading and misleading questions, no? Also no changes. Section 10, Attorney Renz. Okay, no changes there except for gender-inclusive language. The next slide, please. Okay, so you just have juries there, of course. We know that leading questions may only be asked of certain witnesses, and the classic example would be a minor, right? Okay, and you have that quote at the bottom, no, of the page on Section 10. All right. Now we go to the impeachment of the adverse party's witness. Also no changes except for gender-inclusive language, right? Let's go to the next slide for the explanation. Attorney Renz, okay. Okay, so just for clarification, okay, under this rule, no, although the calling party, okay, does not vouch for the witness's veracity, okay, he is nonetheless bound by his testimony, okay, if it is not contradicted or if it remains unrebutted. What does that mean? If I call you, like, let's say I'm the plaintiff, but I call the defendant as my adverse witness, okay, then am I bound by the adverse witness's testimony? The answer is yes, okay? But what does you are bound really mean, no? You are not bound in the sense that you may contradict him by introducing contrary evidence, okay? But if you do not, and the testimony of the adverse witness you called remains unrebutted or uncontradicted, then you become bound because you called him, okay? And you failed in your duty to contradict what he said. Okay, so I hope that's clear, because that is often misunderstood, okay? Just by the fact that you called your adverse, the adverse party as your witness, does not really mean that you are bound completely. You still have the opportunity to rebut or to contradict, okay? Now let's go to Section 12, which is the new provision I mentioned earlier in reference to character evidence under Rule 130, Section 54, okay? So here, the new Section 12 provides for impeachment by evidence of conviction or crime. Okay, so for the purpose of impeaching a witness, evidence that he or she has been convicted by final judgment of a crime shall be admitted if A, the crime was punishable by a penalty in excess of 1 year, or the crime involved moral turpitude regardless of the penalty. Okay? However, evidence of a conviction is not admissible if the conviction has been the subject of amnesty or annulment of conviction. That is only logical, because amnesty or annulment of the conviction erases the conviction. It's as if the accused was never convicted. Okay? So why did the Supreme Court thought of adding this, no, exceptions, no? So, well, because it goes into the credibility of the witness, right? You want a witness that you can rely on, and if you want to be able to rely on a witness, he has to have a badge of honesty to him, no? So evidence of a conviction of a crime is certainly evidence that could affect the court's assessment of weight, no, or assignment of weight to the testimony of a particular witness. Now, you may ask, why only those crimes punishable in excess of 1 year? Why did we not include those below 1 year? Well, the Supreme Court thought that conviction of light offenses or minor crimes does not have as much impeachment value. Okay, so and should not necessarily affect the the credence or the honesty, the badge of honesty or trustworthiness that the court can assign to that particular witness's testimony. Okay, all right, let's go to the next slide. Okay, here we have the provision on a party not impeaching his or her own witness, only gender inclusive language, okay, as well as the subsequent slide, okay, and also section 14 on how a witness is impeached by evidence of inconsistent statements, only gender inclusive language, okay. Right, now let's go to section 15, the exclusion and separation of witnesses. Okay, here, this was revised by the court, no? To add this general rule and 4 exceptions. Okay, the general rule is the court, motu proprio, meaning on its own, or upon motion of any party, shall order witnesses excluded so that they cannot hear the testimony of other witnesses. We know the practical utility of this, okay? So this is really against coaching, and well, in a way, no, in a way, fabricating testimony, because we want witnesses to be consistent in their statements. All right. Okay, that is the general rule. But these are now the established exceptions by virtue of this revision. First, this rule will not authorize the exclusion of a party who is a natural person. So any party who is a natural person, if you're a party, you have a right to be there. No, even if it's not a criminal case, even if it's a civil case, you have a right to be present at every stage. No, okay. So this, you are excluded from being excluded from the courtroom, okay? Second, a duly designated representative of a juridical entity which is a party to the case, all right? If you are extending this privilege to a natural person who is a party to the case, then you should also extend it to a juridical entity who is a party. But of course, because of the corporate fiction, the representative is the one who's going to use this privilege, okay? And then third, a person whose presence is essential to the presentation of the party's cause. Let's say I intend to present an expert witness, okay? So I want my expert witness to be there from the start, because I want my expert witness to form his opinions or to add to the opinions that he will be stating when he takes the stand, by gauging also the testimony of the adverse party's witnesses, right? Okay. And then the last one is a person authorized by statute to be present. The Supreme Court said that they added this provision to cover other exceptions that have not yet been thought of at the present, okay, and that the laws may provide for in the future, okay? All right, and then no changes in the second paragraph except to add directly or through intermediaries, meaning this is regarding the power of the court to separate witnesses so that they do not converse while the trial is still ongoing. And so the court added the phrase directly or through intermediaries. We don't want the counsel to shuttle back and forth from witness to witness, just so he could, relay these messages to them about how to go about their particular testimonies, okay? All right, let's go to the next slide. When witness may refer to memorandum, again, no changes except for gender inclusive language. Now let's go to the authentication and proof of documents. Another important part of our rules, no? So you have section 19 for the classes of documents, still the same. Public documents, A, B, no changes. But then go to the next slide. You have a new paragraph C, okay? So the new paragraph C reads, documents that are considered public documents under treaties and conventions which are enforced between the Philippines and the country of source, no? So this was included largely because of the Apostille Convention, which took effect May 2019. That was last year already, no? 1 year in effect, no? So documents considered public documents under treaties and conventions to which the Philippines is a signatory, okay? And then public records kept in the Philippines of private documents is still there. No? Now it's paragraph D. And all other writings are private in character, okay? Let's go to section 20, proof of private documents. Okay, now the court, we already had this, adding the phrase by any of the following means in the present provision is just stylistic. But then the Supreme Court added a letter C, okay? The first, we had A, anyone who saw the document, executed or written, that was already in the previous rule. Second, evidence of the genuineness of the signature or handwriting of the maker, that was also present in the old rule. But now we have C, which is by other evidence showing its due execution and authenticity. I think this is a very good addition because we should not limit it to A and B. There are other types of evidence that could be introduced to prove private documents, all right? Okay. Let's go to the next slide. Okay, I did a summary for you on this slide as to your classes of documents, and you have public documents at the top. No, what are public documents in terms of proof? No, they are admissible without proof of due execution and genuineness. No, from the mere fact that they are public documents. No, they are admissible. Okay, and what are these? The written official acts or records of official acts of the sovereign authority, official bodies and tribunals and public officers, whether of the Philippines or of a foreign country. Second, documents acknowledged before a notary public, okay, except last wills and testaments. Third, public records kept in the Philippines of private documents required by law to be entered therein. And fourth, public documents under treaties and conventions, okay? That is the addition. Now, private documents. These documents, you have to prove the due execution and authenticity, no? And the method of proof are by anyone who saw the document, executed or written, okay? Second, by evidence of the genuineness of the signature or handwriting of the maker. And third, this is an addition under the revision by other evidence showing its due execution and authenticity. Okay, so this last addition, the other evidence showing its due execution and authenticity, is a parallel provision to section 2 of Rule 5 of the Rules on Electronic Evidence, which allows a judge, no, in authenticating an electronic document to use other evidence showing its integrity and reliability to the satisfaction of the judge. No, so as ever, no, when we come to the weight, no, we have to look at the reliability or trustworthiness of the evidence. Okay, let's go to the next slide. How is genuineness of handwriting proven? No, do you always need an expert to prove the genuineness of a handwriting? We know that the answer is no. The opinion of an ordinary witness, no, on handwriting with which he has sufficient familiarity is acceptable. It is admissible, all right? And we also know, let's go to the next slide, Attorney Renz, that if a handwriting expert is presented, the court still is under duty to make its own examination and assessment of the expert evidence, right? Especially if the challenged distinctions or dissimilarities are visible to the naked eye. In every instance like that, the judge is called upon to make his or her own assessment, okay? And even if expert witness or expert testimony is presented to the court is not always bound to accept it, no? The court can accept parts of it, or the court can accept the whole of it, or the court can reject everything, no, given by the expert. Okay, all right, let's go to section 24. Okay, so the addition here is at the bottom. If the office in which this is proof of official record, okay? If the office in which the record is kept is in a foreign country, okay, which is a contracting party to a treaty or convention to which the Philippines is also a party, or considered a public document under such treaty or convention pursuant to paragraph C of section 19. Next slide. The certificate or its equivalent shall be in the form prescribed by such treaty or convention subject to reciprocity granted to public documents originating from the Philippines. Okay? And then you have the subsequent provision which covers those documents which are from a foreign country which is not a party to the treaty or convention. All right, let's go to the next slide. Okay. Okay, this is the effect. A document that is accompanied by a certificate or its equivalent may be presented in evidence without further proof. Okay, because remember, this is considered a public document. So no proof of genuineness and authenticity is required, okay, except for that certificate. The certificate or its equivalent being prima facie evidence of the due execution and genuineness of the document involved. The certificate will not be required when a treaty or convention between a foreign country and the Philippines has abolished the requirement or has exempted the document itself from this formality. Okay, this is what the Apostille Convention is all about, no? The Apostille Convention is the convention on the which abolished the requirement of consularization or the diplomatic or consular legalization process. Those of you who've dealt with consularized documents, you remember the procedure is executed abroad. Mostly these are notarial documents executed abroad. Then you bring them to the embassy or to the consulate. You have them authenticated, no? You have that red ribbon. And in the meantime, the court proceedings are delayed because we're waiting for that consularized document to arrive, no? So we're doing away with all of that. Because of the Apostille Convention, now the only thing you need is the Apostille Certificate, which you get from the DFA, okay? There's a template which is attached to the convention, and it's very, very short, no? I think only 2 or 3 sentences in it. And when that certificate is attached to your document originating from a foreign jurisdiction, then that should be enough. It will take the place, or it will be the certificate that this revised provision is speaking of, okay? And okay, that's it. Oh, and just a reminder, the Apostille Convention took effect May 14 of 2019. All right, let's go to the next slide. What attestation of a copy must state? Well, this applied before, no? And it will still apply if the document is originating from a foreign jurisdiction or from a foreign state which is not signatory to the Apostille Convention, all right? Okay. Okay, and then the next slide will provide you with the requirements, no, as laid out in jurisprudence, okay? So again, because of the Apostille Convention, all you need now is a certificate unless the document is originating from a non-signatory state, all right? Let's go to section 28, proof of lack of record, okay? So no changes here, again, only for gender inclusivity. But the most common example I can give you of this proof of lack of record is the CENOMAR, or the certificate of no marriage that the local civil registrars or the National Statistics Office may issue to attest to the fact that there has been no marriage involving a particular individual as recorded in our civil registry, okay? Section 31, alteration in document. How do you explain? Still the same provision, only gender inclusive language. Now let's go to offer and objection. Section 35, when do you make an offer? This is important procedurally and substantively because now we have institutionalized the rule that all evidence must be offered orally, okay? This was first included as a rule in the Quezon City Practice Guidelines for Litigation. No? I'm always proud to say that. And we did that many, many years ago. I can't remember anymore what year. No? And then it was copied into the Judicial Affidavit Rule, no, during the circa of Justice Robert Abad. And then now it's also in the Rules on Continuous Trial as promulgated by the Supreme Court and as advocated by our present Chief Justice, Diosdado Peralta. Okay, so all evidence must now be offered orally, no? And then we distinguish between the types of evidence. If it's testimonial evidence, you make your offer before the witness starts his testimony proper, okay? In the judicial affidavits, although the judicial affidavit rule, no, it does not state that the offer should be included. I always say this when I lecture on the judicial affidavit rule, that it is a better practice to include your written offer of the testimony in the judicial affidavit already, because it really makes it easier. It facilitates the raising of objections even to the offer, rather than do the offer orally when you already have the judicial affidavit, correct? And then if it's documentary or object evidence, of course, you make the offer after you have completed the presentation of your evidence, all right? All right. Okay. Now, when do you, of course, the basic premise is that if you fail to formally offer your evidence, the court will not consider it. Okay. Although we know there are exceptions by jurisprudence, but then you have to offer your evidence orally, offer your evidence formally, and this time it is to be done orally. Okay. Now, when do you raise the objections to the offer? Okay. So there you just have, you just have a decision handed down by the Supreme Court distinguishing between identification of documentary evidence and formal offer, no? Just to highlight that the fact that you marked the evidence already in court and had your witness testify on it and authenticate it does not automatically mean that you have offered that evidence already, okay? So if you fail to formally offer it, then the court will also not consider it, okay, unless it falls under the exceptions, okay? Now we go to the objection to the offer, section 36. Okay, so objection to the offer of evidence must be made orally also immediately after the offer is made. So if it's testimony of a witness, then after the offer of the testimony of the witness, before the witness testifies, you already have to make your objection to the offer of the testimony, and the judge has to rule on it. No, the judge cannot say, okay, submitted, and then proceed with the testimony. Okay, to our judges, we cannot do that. Okay, we have to rule on the objection already. Okay, now objection to the testimony of a witness for lack of a formal offer must be made as soon as the witness begins to testify. As I said, this is only to institutionalize the ruling of the court in Catwira versus Court of Appeals, no, where there was no offer of the testimony of a witness, but then that objection was not raised, no, and I believe that there was even a cross-examination of that particular witness. So the court said that that objection was already waived, right? Okay. So the next slide, please. Okay, that's the case of Catwira. Okay, section 37, when repetition of objection unnecessary, also gender inclusive language was changed. Okay, let's go to section 39, striking out answer. Section 39. Okay, so the Supreme Court did some additions here as to when one may move for the striking out of the answer of a witness. So should the witness answer the question before the adverse party had the opportunity to voice fully its objection to the same? Okay, so that's the first instance. Second, where a question is not objectionable, but the answer is not responsive. Okay, non-responsive, you know that. Third, where a witness testifies without a question being posed. Okay, you have witnesses who will talk nonstop, even if no question is being asked of them, all right? And then fourth, if the witness testifies beyond the limit set by the court, okay? And then fifth, when the witness does a narration instead of answering the question, although of course, for certain types of witnesses, a narration is permissible, right? Okay, so of course, this rule provides that the objectionable testimony may be stricken from the record, no? So it's stricken off the record. But practically speaking, we do not really do that. Okay, it remains in the transcript, and that is for purposes of a petition for certiorari, maybe, or a later appeal. We want the reviewing court to have a chance to look at the portions of the testimony that were ordered stricken to make a careful determination if there was really error on the part of the trial court for granting the motion to expunge it. Okay, all right. Okay, now we go to Rule 133, weight and sufficiency of evidence. Preponderance of evidence, no change there. That is the burden of proof in civil cases. Okay, the next slide shows you what our classic definition of preponderance of evidence is. No, it's the weight, credit, and value of aggregate evidence. Simply, it's the greater weight of evidence. No, all right. And then next, you have Section 2, proof beyond reasonable doubt. That's the burden of proof in criminal cases. It is also long accepted, no? What it means. Okay, and then we go to Section 4, which is circumstantial evidence. Okay, here the Supreme Court made one addition, a one-line addition. It says inferences cannot be based on other inferences. Now, just for clarity, no, we are always told that you cannot base your conclusions on speculation or conjecture, no. So inferences cannot be based on other inferences, meaning you have to prove something as a fact first before you can draw an inference from it. In the same way, earlier on, no, with regard to presumptions cannot be the only thing that you have to base your conviction on. Okay. All right. Next slide. Circumstantial evidence. I just gave you here for review, the requisites for the application of that you need to establish so that you can use circumstantial evidence to convict an accused in a criminal case. Okay. All right. Then let's go to the new provision. Okay, which is how to give weight to the opinion of an expert witness. No, this is largely guidance, no, for our judges and of course for our practitioners also. How do we ascribe weight to the testimony of an expert witness? In the case where the opinion of an expert is received in evidence, the court has a wide latitude of discretion in determining the weight to be given to such opinion. And for that purpose, may consider the following. Okay, we have the first three, which are specific guidelines. First, whether the opinion is based upon sufficient facts or data. Second, whether it's the product of reliable principles and methods. Third, whether the witnesses apply the principles and methods reliably to the facts of the case. So those first three I call specific guidelines, okay? And then you have number 4, which is a general guideline, which gives sufficient leeway or discretion for the judges, no? And it states such other factors as the court may deem helpful to make such determination, no? So this is very useful now for our trial judges, okay? And then you have substantial evidence, which is the burden of proof in administrative or quasi-judicial proceedings. Okay, no change also, just a renumbering. And then you have section 7 and section 8 on the succeeding slide. Also no changes, just the renumbering. And then that ends our presentation. Thank you very much.
Thank you very much, Justice Monette. That has been a very long presentation. So we'll give you time to take a short break. Before we entertain questions, I would just like to announce that this is the first of 2 parts. So this is day 1. Tomorrow we'll have another one, and tomorrow will be the one on civil procedure. And also, as mentioned earlier, we are being streamed live via Facebook through the Faculty of Civil Law page, and also that of the IBP Quezon City chapter Facebook page. So we'll try to go through all the questions that you posted in the Q&A box. But for now, we thank everyone who have joined us this morning. Let's see.
Attorney Renz?
Yes, Justice.
We can assure everyone that those questions that we will not be able to answer because of lack of time, Attorney Renz and Dean Nilo will forward to me, and I will answer each and every one of them, and I will give the answers to Dean Nilo and Attorney Renz so that they can forward to you, to whoever asked those questions.
Yes.
So I just wanted to say that.
Yes.
Thank you, Justice.
Yes.
And great
Yes.
lecture, Justice. Great lecture. Great.
Thank
Wonderful,
you.
amazing lecture, Justice.
Thank you, Dean.
We will be posting the link to the updated PowerPoint presentation of Justice Monette in the UST Faculty of Civil Law Facebook page. So watch out for that in a little bit. Justice, okay, let's go through the first question.
Okay.
Section 2 of the Electronic Evidence Rule says it's all civil actions. Does the phrase all civil actions refer to civil cases only, or to any action involving civilians, so that it would apply to criminal cases as well?
Well, you know, the Supreme Court has already issued cases or decisions, no, on this matter, clarifying that it can even apply to criminal cases.
Okay. Another question. Why do you still resort to secondary evidence when duplicates are already considered originals?
Oh, because secondary evidence, well, okay, so we have a hierarchy for our secondary evidence, right? And testimony is only third of that hierarchy. The first is a photocopy. So what you're saying is that if you have a duplicate, okay, you do not have to resort to secondary evidence. You are right, because you have the original. Because a duplicate is considered an original now. It's an equivalent of or a counterpart of the original. So you don't have to resort to secondary evidence. But if all you have is a photocopy, not a duplicate, then you need secondary evidence, okay?
Okay, I think this is a follow-up question to that. Are photocopies or Xerox copies admissible already as duplicate under the new
No,
rules?
no. Okay, let's distinguish. Let's be very clear. This was asked of me also already. Okay, you have the traditional paper document, okay, and then you have the electronic document, okay. A paper document, okay, the original is the paper document itself. Let's say it's a letter, okay, that's your original. You cannot say that a photocopy is a counterpart, okay, because it does not fall within the definition of a counterpart. A counterpart is one which is made under the same impression at or about the same time, okay. That is not a counterpart or a duplicate, all right. So it's a photocopy. That is secondary evidence. You have to justify its introduction by the destruction or loss of the original, or the fact that it's in the custody of the adverse party, etc., etc., okay. But an electronic document, let's give the example of an email, okay? The email is an electronic document. You compose it on your computer. It is stored in your computer. It is sent through your computer. It is received through an electronic gadget, correct? Okay, but now you want to present it to court, you print it out, correct? Now, the printout is a counterpart, okay? It's a functional equivalent of your email, the electronic document. That is an original. It's a functional equivalent. Okay, so there is a big difference between a paper document and an electronic document.
Okay, thank you very much, Justice. There's a question here regarding privileged communication. Just I think asking for a clarification. The spouse can now testify for the other spouse, but not against him or her. Asking if that's correct interpretation, Justice.
Yes, the court changed it to against. No, if you read the provision, they now use the word against. Okay.
Okay, this is interesting. Question on regarding independently relevant statement.
Yes.
Would gossip be considered as admissible evidence?
Well, it depends on the type of on the fact that you're trying to prove, no, and the type of action, no, where it is introduced. It will depend on a lot of things for me to be able to say that that's relevant. That's just too broad.
Subject. Question, is a judicial affidavit itself testimonial evidence or object evidence?
Okay, thank you for asking that. No, I always tell my students that a judicial affidavit is testimonial evidence. Okay, so and even when I was still in the trial course, I always told litigants in my court, do not mark your judicial affidavits because that's testimonial evidence. We do not mark testimonial evidence, right? Okay. Anyway, why do I say that it's testimonial evidence? Because it takes the place of the direct, right? So no more direct examination, you proceed to cross-examination. And that is the reason why I say it's testimonial evidence.
Okay, the same person asking, Justice, would like to know also if exhibits already identified and marked in the judicial affidavits, are they still required to be re-identified and marked during actual presentation of the witness?
No, precisely. The reason why the judicial affidavit rule required that is because we want to dispense with all that marking and comparisons and identification in open court, no? So everything has to be done through the judicial affidavit already. In fact, there is even a criticism that why do we need to do all of these things in the judicial affidavit? We just transpose what we do in trial in open court to the paper, no? Well, in some way, it already helped us shorten the trial time, no? But we're moving towards that, where we get to dispose of all of these things.
Okay, thank you, Justice. Okay, regarding hearsay evidence in drug cases, drug tests performed in the crime lab, are they considered as public document considering it was performed by a public official, or is a chemist not considered one?
Of course, forensic chemist report or the laboratory report is considered a public document. It's prepared by a public servant, a public official, and it's a public record.
Can persons providing moral support to a party, I don't know exactly what moral support, be exempted from exclusion under Rule 132, Section 15?
No, no, they're not under the exclusions. I'm sorry, unless they fall within the exclusion for those who are necessary for a party, no, to prosecute his cause, diba? But an agent, like an agent of a person, falls under that exclusion. So if this person lending moral support is the agent, then you will fall under that exception.
Okay. Are trial court judges given discretion to direct the submission of written offer of exhibits instead of verbal offer?
No. The wording of the rule is no. When it started, there was a proposal to there was actually a last statement there which says that in justified circumstances or something like that, or when the interest of justice requires, 5 days may be given for a written offer, no? But in the final version, the one that the Supreme Court approved, wala na. They removed that, and I'm all for it. No, we should do it orally.
Okay, we'll only be able to accommodate maybe a couple more questions, Justice.
That's okay.
We're running out of time, so if we're not able to cover your questions during the live session, be rest assured that we will forward everything to Justice Singh so that she'll be able to give us the answer, and then we'll respond to you via email.
Yes, we will do that.
There is a clarification, Justice, on the effectivity of the rules. Would they have retroactive effect or it's prospective in application?
Okay. The doctrine always is that they apply prospectively, right? Okay. When we say they apply prospectively, they apply to pending cases. Okay, those which have not reached the decision stage, so they will apply to those cases which are at pre-trial stage or the start of trial, no? So that's my understanding for this particular, the same rule applies to this particular set of revisions.
I think, Justice, that's all the time we have for now.
Okay.
So for the other questions, I'm seeing other questions. Some of it have already been covered by the lecturer and also have been answered previously. But for the rest which have not been answered, we will be answering them via email. So again, thank you very much, Justice Singh, for your time. We will see you again tomorrow, and to everyone who joined us, thank you very much. See you again tomorrow. Good afternoon to everybody.
Thank you.
This has been Attorney Renz Mayuga. Thank you.
Thank you very much. Thank you, Dean. Thank you, Attorney Renz. And thank you to all those who stayed with us through the 2.5 hours.
Yes.
Thank you.
Thank you po. Good afternoon, everyone.
Good afternoon.